WDXE News, on the air since 1951. This is The Legend. 105.3, 95.3, WDXE.
Hey, that's us, and us right now is myself and Mr. Stan Pierchoski. Bulletproof estate planning with Pierchoski Estate Law. As you know, it's that time. It's Friday again. How about that?
You are correct, Mr. Producer. It's correct, Jeff. Bulletproof estate planning every Friday morning from 8 to 9.
Yeah.
I get a lot of folks that come up to me and say, "Hey, I listen to your show on that." And I ask, I do a couple of shows, and I always say, on which station? And
Yeah.
you get a lot of response here on Lawrenceburg at WDXE. Yeah. So this experiment you guys are doing with the talk show, because people, when they listen to a talk show radio, they don't listen to just one thing. They kind of listen to what goes on all the time.
Sure.
And I do too. I like music as much as the next guy, but I don't like it all the time.
Right.
It's a nice break to listen to stuff, and so
I agree.
So it seems like it's working pretty well. And somewhere around June-ish or so, I can't remember, but somewhere around that, beginning of the summer is when it actually went with this. When we actually started doing the show.
Yeah, time flies. We've been doing it for a while now, and so far it's been very well received and a good success. We're happy with it.
Yeah, and this show I'm doing, come Mother's Day, the one I do out of Nashville with the same name and everything, come Mother's Day, it'll be 3 years, and that just shocks me. How can you find so much to talk about in estate planning for?
Well, there's like you say, almost every circumstance is slightly different.
They are. They sure
are. Families are diverse.
Mm-hmm.
They have different possessions, different ways they own things. There's a lot to consider.
There is, and and it's personal. And from my standpoint, like I often say, from my side of the table, it's what you want to do is what's important to me, because whatever that is, if it's important to you, then that's what we want to have accomplished. And you're right, it is all over the board sometimes. You would think everybody just says, well, I got this many kids, just divide it all up into by that fraction and give it all to them. And that is popular, but it's by far, there's many, many more things that happen. It just amazes me sometimes. So, hey, before we get started, just want to say the next seminar we're doing is coming up on May the 18th. That's about, 3 weeks out. And
That's right.
It's right here, WLX radio station in the back of the building at the Country Cafe. It's a Saturday. And, of course, Saturday seminars, we always try to start as promptly at 10 o'clock as we can, because they last about an hour to an hour and 10 minutes. And then we have a pretty lengthy Q&A afterward, and which we encourage, and I'll stay until the last question's answered, which that's really my favorite part of the whole thing, because I get to know what people are thinking, their experiences, the things they're running into, and that's where the rubber meets the road when we talk about question and answer. So if you want to come to that, please do. We call it Will's Trust in the Nursing Home, and if you want to get exposed to some of this stuff, at least get the thought process, because I know people who want to do estate planning go online, they start looking to see what to do, and they probably end up with more questions than they get answers. And the answers they do get are either, at the least, they're wrong. At the most, they're almost just completely off the chart.
Yeah.
I don't know where they come up with some of these concepts that I actually I don't even do it much anymore. I don't really research it myself. But I used to, and I know what's out there. So don't rely on that like anything else. Like anything else you pull up on YouTube or something. There's a dozen different ways that people have ideas on how to do stuff. And some of them are pretty creative and useful, and a lot of them are just not. So that's not the best place to get legal advice. So
I concur.
But come to the seminar on May the 8th. We don't do them as often because we do them in different places, and we just stay so busy. But
and this is free of charge, by the way.
Oh yeah. Now I don't like to focus on the word free, but it is. There's no charge for it. I don't. I do this as an educational tool, and I've said many times, an informed decision is the only decision a person should make.
Yes.
And so, a lot of people don't know they have options. They don't know that there's other things than just a will that they can do. Everybody hears, last will and testament. Well, that's not the only thing you can do. There are options to that. That's what we talk about, these trust plans, and then those have a lot to talk about, So there's a lot of different things that you can do. Yeah. And, this business about protecting your assets from long-term care. Most people in my age bracket or a little more become concerned about that.
Yeah.
When you don't know what's going to happen to you. And, as you get older, you get things going on. And people start thinking about it this way. They know that if something starts happening to them, they don't want their family to have to take care of them. if you put yourself in the shoes of somebody that needs help, they want to be at home. There's no doubt about that.
Yes.
Everybody would rather stay at home, or what we call age in place. But you also don't want to be a burden to people.
Right.
At least the majority of people I talk to do not want to be a burden to their family.
Right.
And so if that's the case, you're faced with this concept of if something does happen, I may have to go someplace where I get taken care of. And if that happens, now you're faced with the cost of that. And it's very high. We talk about it. The average is $9,000 a month, pushing $9,500 now. It just always keeps creeping up, and it's never coming back down. And it's very expensive. And if it's very expensive, then your mind starts to reel a little bit, because how are we going to pay for this? Just get your calculator out and do the math. And $9,000 a month,
it eats up
and,
fast.
and multiply it and see what. See how long an estate can withstand that rate of financial bleeding.
That would run through my savings in a couple of days.
I said, well, yeah, it's finite in most cases, right?
Yeah.
There's going to be a bottom of the well there somewhere.
Yeah.
Some more than others, but nonetheless, you're going to run out.
Yeah.
And then other things start coming to play. Well, if I'm married and I'm the one in the home sucking up all this money, what about my spouse? What are they going to live off of?
Right. You're right. There's so much to think about.
Yeah. I mean, I think I talked about that case last week where, the had given away so much property during life that the penalty period was like 50-some months, and their entire net worth that they had not given away would only get them to about 25 or 28 months.
Yes.
Which means and at which time the spouse would be impoverished.
Yeah.
And they still couldn't pay. So that's a bad place to be. So,
Right.
It's just exorbitantly expensive. And anyway, what I want to talk about today is an experience which I like to share.
Sure.
I'm going to try to keep my calm. I'm going to try to enhance my calm when I talk about this, because it was kind of I love a challenge. Let me start off with that.
Yes.
I love a challenge, but sometimes the challenges are exasperating, because I used to be an engineer for many years.
Yes.
And that you don't ever lose that thought process.
Yeah.
And I'm very logical. I'm very I dotting and T crossing and rule following, and
Yes.
and when I get a challenge that's outside the realm of my ability to comprehend, not that I can't comprehend how it gets that way.
Yeah.
It's a challenge that gets frustrating.
So you wonder how it got this far out of whack.
Well, sometimes I feel like I'm at such a disadvantage because I'm the only one following the rules, and that is not the way it should be. So, anyway, thus this story. I want to, and again, I'm going to beat up on the TennCare system. So I'm not beating up on any person.
No.
I'm beating up on the administration. And if you're somebody in TennCare and you listen to me, I say this all the time. If I'm missing something, because I'm not a fly on the wall in TennCare, so I don't know what's going on. I don't know how these decisions come about.
Right.
All I get is the decision when it comes about,
Yes.
or doesn't come about, which is part of the story. And I have to live with that. Now, if somebody wants to call me and explain to me, I'll be the first one to eat my words and say, you know what, I didn't know that. Thank you. And I will have an open mind. But I don't get those calls, right? But I invite them all the time.
Yes.
So we got a client, and it started out with what we call a do-it-yourself TennCare application. Now, I really don't think that's what caused all this, but some of me, maybe a little bit. But anyway, so the do-it-yourself application is when somebody decides to get a loved one qualified themselves.
Yes.
You can get the TennCare application. Just type in TennCare eligibility application, because it's really not under TennCare. The TennCare system is called Age, Blind, and Disabled is the name of it. And that you can just call up there and say TennCare application. You'll get a place where you can go to a PDF and print it out. It's a 16-page application.
Okay.
It's pretty lengthy, and it asks a lot of questions about your health and your spouse's health and stuff like that. And then it asks a lot of questions about assets and income, okay, because that's the eligibility application.
Yes.
And sometimes people think, and really when you read the application, they don't look that onerous, the questions.
Yeah.
They just kind of ask, what do you own? What do you get for income? What's your Social Security? If you get a pension, just kind of straightforward questions.
Sure.
It's like, I can fill this out. The problem is what they do with the answers that you don't know. That's one problem I see. We fill them out. We know what they're going to do with the answers.
Right.
So we make sure that the answers fit into the rules, which means sometimes we have to do things before we send the application in.
Yes.
But what we want it we want our posture of our assets and our income, and to some extent our health, to be where we want it when we apply.
Right.
So if you come to me and you got too much income, it's like, well, no sense sending in an application. They're going to punt it because you're over the cap.
Yeah.
I mean, it doesn't take a PhD or a college degree to figure out that if we send this in and you're making $4,000 a month income, that it's more than $2,835, and they're going to deny it. I mean, it's just no sense doing it.
Right.
How about we modify your income to get it below the cap, or use a qualified income trust that allows us to be over the cap, but we've got to put it somewhere, and then file the application. So
Yes.
that's sort of like our process, and we do that with your resources too.
Sure.
So anyway, we get back to this case, and we got this do-it-yourself application. They came to me, and I was reluctant to take the case, but I did, and I couldn't resurrect the original application. I mean, there's sometimes when they deny, you can't recover from it. Sometimes if they deny, you can go in and show them that they did something wrong.
Yes.
But this was a denial just flat out on the reason. Said you're over-resourced. And they were over-resourced on what we call our snapshot date.
Yeah.
And so there's no say, oh, okay, let me go back and do something with that. Okay, there's no coming back from that. The only opportunity is to file another application. So what we did was we cleaned everything up. We got it the way we wanted. We filed a second application.
Yes.
And that would come back with a denial for, again, being over-resourced, which was confusing to us. So we filed an appeal. And then shortly after that, we thought, okay, let's take a Plan B position and file a third application where we're going to, I won't get into the numbers, but we filed a third one where we have literally forced them into eligibility. We had made it in such a way that there's no way they could say no. And the reason we filed the third application was because we didn't want them to take forever to look at our second one.
Yes.
And give us our appeal while we were in this mode of paying, right?
Right.
So, anyway, we heard from them, I'm going to say, back in October, November.
Okay.
Something like that. And then they denied it. So we had two issues going on. Let me cut to the chase and say we appealed this case. They gave us a denial, what I call an inappropriate denial, because I know how they're supposed to figure these things, and they didn't figure it right, or according to the rules.
Okay.
There were two things going on. One, they calculated the snapshot date wrong.
Okay.
You know, I take the position on a snapshot date if you're a married couple. It doesn't apply to single people, just married couple.
Yeah.
There is a date and time that they figure up, and that's the day they look at all your resources. That's the day you got to be below this, and you got to be below that, and you got to have all these things. And
So that's what you're referring to when you say the
snapshot date. It's a moment in time, because it's hard to look at a fluid situation. You know what I mean?
Right.
So the snapshot date is kind of defined like this. I mean, it's a word problem. You can only get one answer when you do it.
Yeah. Yeah.
You know, it's the first day of being confined for 30 continuous days. Now, the confinement can be tacked with the hospital and then a facility. So, you know, here's how it typically works. You go into the hospital on, I don't know, let's say, April 15th, right?
Okay.
You're there for 3 days, 4 days, I don't know, and they discharge you to the facility, right? And you're at the facility for, I don't know, another 25 or 26 days.
Okay.
Once you reach the point of 30 continuous days of confinement, now your snapshot date is that first day, so back to April 15th.
Okay.
And so,
Okay.
because some people go and get released, right?
Yes.
Now, you know, so we have the snapshot date. And like I said, so they're going to go back and when you file you may not file your application for, I don't know, months after that. But when you file the application, they're going to go back and look at all the bank records and everything on April 15th. And that's what they're going to determine it.
Right.
Now, there's a little more to it, but it really is there's a procedure for calculating the snapshot date. And so whenever you do it, you can only get one answer. I mean, it's a math problem.
Yes.
Math is absolute. Anyway. So they calculated it wrong. They came up with a wrong date, and they said you were over-resourced on that day. And it's like, well, we were over-resourced, but that's not the snapshot date. That's not the day we have to be properly resourced on.
Right.
And so, and then they also, you know, we talk about giving away property and getting penalized for it. Yeah. This was a situation where they'd given some money away to a child.
Okay.
And the bank records clearly show it.
Yes.
And we also showed the bank records because when they came to me, I found that, and I said, you know what, we need to give that back. Because in Tennessee, you can cure a gift.
Yes.
If you give it back. So if you give property away, they impose a penalty period. But if you get the property back, they cure it. Now, it's not like they're doing you a favor curing it. You got to look at TennCare's position. If you have, you know, let's just use this. Let's just use the value of $100,000, a nice round number.
Yeah.
If you give a child $100,000, just give it to them.
Yeah.
They're going to penalize you. And what's their logic for doing that? They're going to say, you know what? If you'd have kept this, you could have paid us. So let's say a penalty period for $100,000 is going to be, let's see, divided by 8,222, or 220, is roughly 12, maybe 12, almost 12 months.
Yeah.
Okay, so a year. And so they're going to say, look, we're not going to pay for 12 months. You're eligible. We looked at your application. You are eligible. We're ready to pay, but we're not going to pay for 12 months. And our theory is if you'd have kept that $100,000, you could have paid. So why should we be out of pocket if you could have paid? And why should we be out of pocket if you just ditched this and gave it away?
Yeah.
And now we have to pay.
Yeah.
And of course, you have to make this gift within 60 months of filing your application.
Right.
So now the reason they'll cure the thing, it sounds like, oh, they're doing us a big favor by curing the penalty. No, not at all. Here's what happens. So in this case, just using it wasn't $100,000, but it's a nice round number. And I say, we need to give that back. So the child gives the parent back $100,000, right?
Yes.
Now the parent has the $100,000, right?
Yes.
Are they not in the exact position that TennCare just said they would penalize them for if they hadn't done it? So, your position has not changed one iota.
Right.
You now have the asset back. Right? I mean,
Yes.
TennCare's position is not one iota because now TennCare is going to say, okay, you're not eligible. Now you're no longer eligible yet. You'll be eligible in 12 months if you pay for your nursing home bill for 12 months.
Right.
Now, TennCare still doesn't pay for the next 12 months. Do you see the?
Yeah.
You see where it's going?
We're in the same
With
place.
the penalty period, they're not going to pay for 12 months
Right.
because you gave it away. If you get it back, you have it the private pay, and they're still not going to pay for the next 12 months. So their position has not changed. That's why they allow the cure. It doesn't affect them one bit.
Right.
It's not. They're not being magnanimous and saying, "Here you go. This is a present from TennCare." Curing it's no big deal. And Tennessee allows partial cures as well as full cures. If you only get half of it back, you can minimize the penalty period.
Right.
So we did. We gave it back, and the bank records are so clear. They show the money leaving the parent's bank account. They show the money being deposited in the child's account.
Yep.
They show the money leaving the child's account and being redeposited in the parent's account. So
Right.
it was a cure. We documented everything. And when we get this denial from them, which we got back in October, they said, okay, you're eligible. And then they said you're eligible as of a certain date. And that was the first thing we had issue with. It shouldn't have been an October eligibility date. It should have been an April eligibility date.
Yes.
Okay. And so we have that issue. But then they said, okay, you're eligible as of October the 24th or something, 2023.
Okay.
But then, and here's a pet peeve I have with TennCare. When they give you a response, they give you 20, 30 page letter. Of those 20 or 30 pages, 27 of them mean nothing, just nothing. And it is totally void of the reason they're denying you.
Yes.
But in this case, they said you're eligible. You're eligible, but then they say, but you're denied for TennCare choices, but you could be eligible in November of 2025.
Yeah.
That's all they say. Now, to me, I look at that and I say, okay, they're imposing a penalty period because they're not giving us any eligibility until November 2025. And the only way
Right.
they can do a penalty period is if we gifted something away. And when you divide the penalty period out, how you calculate it, it just magically is the exact number of this gift that was given to the child and was turned around and given back. Mm-hmm. So we know that's where it's coming from. Now, they don't say that. Why wouldn't they just say,
Yes.
you inappropriately gave away this $100,000, and so we're punishing you for it? I had so much more respect for them if they just come out and tell you. But they don't. It's void of that. So we have to derive it from this puzzle, okay? But we're kind of getting pretty good at that.
Okay.
So then that was in the second issue. We appealed. They said, wait a minute. You can't impose a penalty period on a gift that was cured.
Yeah.
And so we called them and tried to talk to them. We always try to resolve stuff before a hearing.
Right.
And they don't, sometimes they do. But
Yep.
they didn't want to talk about it. So we filed an appeal. And in an appeal, you read the notice. It says, if you think we did something wrong, you can appeal. Let us know what you think we did wrong, and we'll review it. But you can have a fair hearing. So when we file an appeal, we file a cover letter, which has got all the issues of appeal on it.
Yeah.
Because, you just have to tell them you want to appeal. But they say, if you think we made a mistake, tell us why.
Yeah.
So they're inviting us to tell them what we think they did wrong.
Yes.
Is that not? Am I
Seems
missing?
reasonable.
Am I missing something when I read that two sentences? Now if it was an encyclopedia, I might miss something. But in that short statement, so we file a letter with the cover letter with the appeal, and we give them the reasons what we want to argue about at the fair hearing.
Right.
And we brought up the snapshot date. We said you calculate, and not only that, we give them the answer to the puzzle. We say here's what you did wrong. Here's what you should have done. Here's
Right.
the date you should have come. And the penalty period. Here's the penalty. Here's the gift. Here's the penalty. Here's the cure.
Right.
No penalty. Okay. And so we tell it to them, and we even go so far as to put on this cover letter in big bold letters, do not ignore this letter, because we know they do. Okay?
Yes.
So we send it in. Now, here's the part that starts to get pretty squirrely. And, you know, if you're wondering what the point of all this is, you don't have to follow all the little nuances that go through this. The point of this is, if you do a do-it-yourself application, and this happens to you,
Yes.
you have no hope, none. I like to think there's hope everywhere, but you have no hope of being successful when this kind of stuff happens. First of all, when you appeal, you have to know that they did something wrong. And to know that they did something wrong, you have to know and understand the rules, right?
Right.
The eligibility rules. And
Right.
they are a quagmire. There's a lot of going on with those. You hear me talk about them all the time. There's
Yeah.
a lot going on.
Yeah.
So you got to know what they did wrong. If that's not bad enough, now you got to know what they should have done that they didn't. Okay? And you can't just do a naked appeal and say, well, I don't like your answer. Why? Well, I just don't like it. I mean, that fails. It's a matter of proof, right?
Right.
You go to court, they don't want to hear what you think. They want to hear what you can prove. What they do wrong.
Correct.
What they do wrong. And if you're appealing, they really don't have to do much to defend. You have the burden. So anyway, here's where it starts to get aggravating to me. Now, when we appeal, we set everything up by giving them all those reasons, right?
Right.
It's not like regular appeal in a court. You appeal, and then they decide when the hearing's going to be.
Okay.
I mean, it's not, you know, when I was in regular court, criminal court and stuff like that, you go into
Yeah.
court and, you know, the judge is there, you're there, the opposing attorney's there, maybe some other, and they say, okay, let's reset this to, you know, May the 15th. Well, and okay, that's okay with me, Judge. Well, sorry, Judge, I got depositions that day. And okay, how about May the 25th? And you go through, depending on how many people are there,
Right.
you go through a bunch of dates till you finally hone in on one that everybody's available and puts it on their calendar, okay?
Right.
And that's how it gets continued. Well, it doesn't work that way with TennCare. They have 90 days to tell you when your hearing date is. And when you get it, they give you the date and what time of day it is. And
Do they have to give you a hearing within 90 days, or they just tell
they have to
when
let you
it's-
know when it is in
Within
90
90
days.
days.
And they're the government, so they get 90 days. But the rule is clear. They have 90 days.
Okay.
That they have to give us a hearing.
Okay.
So a lot of times when the client's like, what's going on? Why are they taking so long? I say, well, you know, they got 90 days, and, you know, I can't, you know, if I call them and try to push them, they can just play that card because that's right in the rules.
Yeah.
And so they're so bogged down that, I guess I assume they're so bogged down that, you know, it's always close. You know, well, this case, the 90th day was like March the 20th.
Yeah.
Okay, just recent. And so and nothing, silencio. And I'm thinking, okay. You know, and so I call them. We call them. Member of my team calls them, and we're kind of saying, okay, before, you know, we're just a little reminder, reaching out. 90 days came and went, and so we're kind of wanting to know when our hearing is.
Yes.
And they dodge your calls, or you can't ever get anybody that can make the decision. And so it got to be about, I don't know, 2 weeks passed.
Yes.
And I'm taking the position, look, you just can't blow me off. I mean, the rule is clear. The rule is black letter law.
Yes.
It's absolutely clear that
Right.
they have 90 days and they failed. So now, but the rules are silent on what I can do about it.
Okay.
So for me to do something about it, I got to step outside of those rules and get into general court rules.
Yeah.
Okay. So there's an action. It's one of the four what they call extraordinary writs. When you talk about a writ, everybody thinks about writ of habeas corpus, right?
Yeah.
Well, there's actually three others. One of them is called writ of mandamus. And a mandamus commands action. So you go to a higher court and you file a writ of mandamus and says, listen, this lower court is not violating the laws. I'm entitled to a hearing. They haven't given it to me in the statutory time that they're supposed to. I want this court, which would be a chancery court.
Yeah.
I want you, higher court, to order them to do what they're supposed to do. I have done a mandamus before.
Okay.
And it works. If you can show that they didn't do it.
Yeah.
And it works. And so I draft one. And I'm thinking, you just can't blow me off. I have to do something. I got to represent my client. We just can't sit here and you just ignore it forever.
Yeah, just ignore it. Yeah.
And so now, if you're a do-it-yourself application, it happens to you, what are you going to do? You're just going to wait them out.
Yeah.
If they would ever respond, right?
Yeah, exactly.
I mean, if you don't call somebody their mistakes, they have no motivation to do anything about it. So I draft the mandamus, and then I even go this far. I call them up, and I finally got somebody on the phone, and I told them, I'm filing this writ of mandamus. I mean, I told them, you can't just blow me off. I gave you the 90 days. I didn't pester you. Now it's been 2 weeks after the 90 days. I mean, I know you're busy. And if you just tell me, if you would just say something like, listen, I promise I'll have that out by next week. I'd say, all right, I'll wait another week.
Yeah.
And I would have done that.
Yeah.
But I just told him, I said, look, I'm filing this Friday of this week or something. If I don't, and I won't file it if I get an answer.
Yeah.
And I was cordial about it, but I mean, I'm just telling you, this is the card I got to play. And you put me here, not the other way
Right,
around.
exactly.
I'm not being hard. You know what? You put me in this position.
Well,
My
yeah.
client is asking me all the time. Well, it's past 90 days. It's like,
What's
well,
happening?
I have to do something.
Yeah.
So we do this. Well, magically, 2 days later, this was on a Monday or Tuesday, and I was going to file Friday, and I think it was 2 Fridays ago. If I can,
Yeah.
I lose track of time, but it came. So that Wednesday or Thursday, we get the letter.
Yeah.
And it gave us a hearing, and the hearing was a week ago Wednesday, I guess.
Okay.
So it was like 10 days. 10 days, you get the hearing.
Okay.
And it's going to be at a particular time, like 3 o'clock in the afternoon. And so that's okay. We're used to them setting the date. That's what they do. Okay, so have the hearing.
Yeah.
Now, remember, when I filed the application, we gave them notice of all our issues.
Yes.
So they knew what we wanted to argue about.
Yes.
It was perfectly clear. We made a record of it. So we get to the hearing, okay, and it's telephonic. They do all that now. You could do them. They were mostly telephonic before COVID, but now they're all telephonic.
Okay.
And which is okay, which is convenient.
Okay.
But sometimes when you get on there and you got witnesses, it's a little cumbersome. But we've gotten used to it.
Yeah.
So you get on the hearing, and we're the moving party. We're the appellant. So it's like the moving party is always up first. You usually make a little opening statement.
Yes.
Then they make an opening statement. Then you start calling your witnesses, and they get to cross-examine them. It's the regular it's an administrative court.
But this is not happening in a courtroom setting.
No, it's telephonic.
This is happening on the phone.
And
Okay.
now, but the rules they're still the same rules. The witnesses, or you call witnesses, and they're on the phone. They come into the call.
I had a question. Is there an actual judge who's hearing this?
Yes, it's an
Okay.
administrative judge.
Okay.
It's an administrative hearing.
Okay.
So it's a lower level judge, but
Okay.
lower level court.
All right.
The rules still apply. It's a little on the loosey-goosey side, but not.
Okay.
I mean, but there's still the rules, right?
Okay. Very good.
And so we get to make our opening statement, and almost immediately after the judge, we kind of said, "Okay, are you here, Mr. Pierchoski? Yes, I'm here. You ready to proceed?" And so, "Yes, I am." And you get your witnesses and everything. "Yeah, I'm all ready, Judge." 10-care attorney, are you ready? And got everything you need? "Yeah, I'm ready." So okay, so it's time for me to speak.
Yeah.
Right?
Yeah.
And it gets jumped in by the 10-care attorney, and he says, "We want to request a continuance. We are not ready or prepared to discuss the issues they want to appeal." And I, in judicial terms, pretty much said, "Are you, kidding me?
kidding me?"
You got to be kidding me."
Yes.
And they said, "We thought we were just going to argue this one thing." And so I now went on, and I said, "Look, no way. I do not agree. There's a little rule say you can get a continuance by agreement or judicial authority." So it's like, and he was asking. I said, "No, I do not agree. This thing's been hanging out here." And I just spilled it out to the judge and said, "Look, they cannot claim no notice. I gave it to them. I had the letter. I held it up. I even put the words on it in like 72-point font. Do not ignore this notice, okay? Because they do. And I even said that, Judge. I said, that's why I put it on there, because they don't look at it.
Yes.
And I have to make a record somehow. Your appeal process is so loosey-goosey. I got him. And so he was convinced that I gave him notice, and then the judge asked, why aren't you ready? Well, we just didn't know that we were going to talk about it. And I said, I would like him to explain to the court how they didn't know. I mean, what process did you come to the I don't know response? How do you possibly get there?
Well, they've obviously had it for 90 days.
That's
And then
anyway.
some.
So not to belabor the point, went back and forth a few times.
Yes.
And the judge, which did not surprise me, said, "You know what? I'm going to allow him that." And I said, I started to say, I want this expedited. And he, he said, he kind of cut me off and said, "But we're going to set this rapidly. There's been enough time go by on this, so
Yeah.
I'll give you your splitting the baby. I'll give you the continuance, but not for very long."
Yes.
Now we don't know how long that is yet because we didn't come up with a date.
Okay.
So now, but anyway, there is a little encouragement in this story. So while we're there, this is a recorded line. It's
Yes.
because it's a actual hearing.
Yeah.
And so what I got them to agree that it would be expedited. We're not tolerating the 90 days again.
Yes.
They don't get that. You
Yeah.
can't do this forever. And all I'm asking judges, they follow the rules. Their rules. I didn't write them.
Yes.
They're 10-care rules. If you can't follow your own rules, we're just all screwed.
Yeah.
Because then they just do whatever they want.
Yeah.
Anyway, so he agreed. He said, "Yeah, we're doing this rapidly." no undue delay. And I even pointed out that, hey, the issues are extremely simple, so I don't want to hear an excuse. We need a month to research this. I've already told you the answer. You need a month to research how you want to try to explain it away is what you really need. But anyway,
yeah.
So
yeah, exactly.
And they also put on the record that none of these issues that they would all be preserved for the next hearing.
Yes.
They came out of two separate actions. I said I want them consolidated and I want them preserved. I don't want to. They cannot raise this issue again that they're not ready. Yeah. Or didn't know we were going to do it. So anyway, one thing, but that was pretty much the end of the hearing, except there's one thing that was encouraging about it. And I'm trying to read between the lines, like you have to do with ThinCare, right?
Yeah.
And the attorney said, well, if you can get me a timeline, we call it a timeline. It's like the listing of the facts and the chronological order. Because, like I said, when you're dealing with something like a snapshot date, chronological order is important, okay? Or filing the application. Because remember what I said? I said if you have too much resources, you can do something with the resources and then apply. Mm-hmm. But if you apply while you still have the resources, you just shot yourself in the foot, right? So they wanted what they call a timeline. We said, certainly, we'll be glad to give it to him. And he said, is it all right if after you give that to me, I call and we talk about it? We said, certainly. What I'd like to say, just like the 20 times I tried to call you and you wouldn't answer and wouldn't talk to me. Yeah, yes, I said, certainly, we'll be glad to do that. And then they made a comment that, I think we could probably do that. We can sit and talk about it, and maybe in exchange for withdrawing the appeal, or something along the lines. He says, if we pretty much give you what you want, would you withdraw the appeal? And now I'm thinking to myself, what a stupid question. It's a stupid question because why am I appealing to get what I want, right?
Right, exactly.
And he says, well, if we give you what you want, would you withdraw the appeal? So anyway, I try to keep a poker face out of respect, and I say certainly, and I qualified and said if we get what I want.
Yes.
And I changed the word. I didn't say what I want. I said if we get what we're entitled to.
Yes. Because
that's what we're doing. It's not what I want.
Yeah.
I want them to pay nothing and give them the Taj Mahal to live in and top-notch service, right?
Yeah.
But anyway, I left the phone call thinking this appeal, in my opinion, is going to be resolved by agreement. That next hearing, it's not going to happen. I'll keep you posted. But in my opinion,
so this is where we're at now.
This is how we're at. When we show them, when they actually look at what we sent them, now we're going to send it to them again, right to the guy.
Yeah. Who
probably never saw it. I mean, I don't know what goes on behind. If I was a fly on the wall in ThinCare, I don't know if I could live with the chaos and the illogic. It would drive me crazy. But now we're going to send it to the guy. He's going to see, in my opinion, he's going to see what we have to show him. And we are going to paint him into a corner that he just can't do anything but approve.
Yeah.
Because everything is in place. Under the rules, there is no escape for them. There's no argument they can make.
Yeah. Yeah.
That they can say denied. And he's going to see the mistake. And then not only do we say this is what you did wrong, here's the authority and what you're supposed to do, and if you have to do it. And it's just clear that they didn't.
To me, it's almost like you're helping him do his job.
Well, we are. We're doing it for him.
Yeah.
So that they'll give us what we want. Now, we shouldn't have to.
Yeah.
Now, we got to do all this, and like filing this mandamus. I know how to do it. It's not done very often. You got these 4 writs: writ of habeas corpus, which is bring me the body and to get somebody out of jail.
Right.
You got this writ of a mandamus, which commands action.
Yeah.
You have a writ that's the exact opposite, called a writ of prohibition, which stops action.
Yes.
And you got a writ of quo warranto, which is that's a complicated one. But nonetheless, they're called the 4 great writs, or the 4 extraordinary causes of action. And they get the court's attention when you file one. Because they are very special and very powerful. And but I shouldn't have to do that. I should rely on the rules, right? I should be able to rely that they're going to deal with me in 90 days. Mm. So...
I had a question
you can hear my voice. I'm frustrated, right?
Yeah, you are. I can tell.
I'm frustrated because I can feel sorry for somebody who tries to do this on their own. If you want to try and do it on your own, I can't stop you. I don't advise it. But when you get your tail caught in this crack, you're not going to know what to do. You're not going to go why they're doing it. You're not going to know what you do about it. You're going to just throw in the towel.
Well, you're going to assume that they're doing.
That's right.
You're going to assume that what they're doing is correct, and you have no choice.
And you're going to throw in the towel. And then they get away with whatever they're doing.
But they're not always correct.
But no, they're often not correct.
Often not.
And the rules are complicated. So when you hire people, I don't know how much training they get.
You mentioned during the telephone hearing there that it was recorded. Now, do you get a transcript or a recording of? I mean, do you have?
I'm entitled to one.
You're
If
entitled to that if you need.
I mean, if the hearing goes well and I don't want one, I don't get one. But
Yeah.
if I need one,
But if you needed one, you
Yeah,
could have
yeah,
one.
it's
Okay,
available.
that was just
Yeah,
kind
it's
of a
available.
passing thought when you said that.
well, it's a court of record, is what we call
Okay,
it.
okay.
Like if you go into, like our general sessions courts we have,
Yeah.
are not courts of record. But if
Yeah.
you want one, you can bring somebody in that'll record it. Or now some of them, sometimes judges will record them anyway
Yeah,
and just keep them.
Yeah.
And if anybody wants it, they can just get a hold of it. Like with a computer or something. You get a computer with a couple terabyte hard drive, and you can just
Yeah.
record things, especially hearings, not the docket calls and stuff like that.
right, right.
But when you get into our circuit court or our chancery court, those are courts of record. So everything they do, they've got a stenographer there.
Yeah, yeah.
And that's, except for some civil stuff. You're not entitled to a record in civil stuff. But if you want a record, like if it's a divorce or you're suing somebody for money, if you want a record, you got to hire your own stenographer and bring it
Yeah,
in.
yeah.
But like in criminal court, everything's under record. So now this isn't criminal; it's civil, but still, it's the record is made and it's available.
Yeah.
So, and I could probably count on just a couple of fingers how many times I've actually requested the transcript. I don't get a transcript; I get the recording. I pay somebody to transcribe it.
For someone who is or would try to be, this would be very intimidating for someone who
Oh,
was
my God.
trying to do it themselves.
Actually, I told you in the beginning, this was born out of a do-it-yourself application, and the person that hired me, it was just that. It was just
Yeah.
that. We, I could do a whole radio show on the reason how this happened with that person, but when you help somebody fill out their application, it says in there that you are an assisting person. Okay,
Yes.
that's what they call it, assisting person,
Yeah.
and you can help somebody fill out an application, and she did. It was her father, so
Yeah.
she helped fill it out, send it
Yeah.
in.
Yeah.
And then it denied, and she actually showed up at the first telephonic hearing before I got on board. Okay?
Oh Lord. Okay.
Didn't have any clue what she was going to talk about, but it turned out she didn't get a chance to talk at all because when I get there, the TennCare says, well, this person's not power of attorney for him, so she has no standing to even be in this court. And she's like, well, I filed the application for him. And they said, yeah, but you don't have power of attorney. And so you can't speak for him. And so she was completely lost. She thought, okay, well, how come she's saying you accepted the application.
Yeah.
You said I could act for him. Now you're saying I can't act for him. Okay,
Yeah.
well, now we're splitting hairs. And I think I'll do that next week if I can think about it. I'll bring in the TennCare application. As I go through it,
That's a good idea.
you will see that there's like 3 people, and it's hidden in the language. You got an assisting person,
Yes.
you got a power of attorney, and you got something, the name they call it escapes me, that's somewhere in between. And they have different authorities. And what the TennCare guy was telling her was correct.
Yeah.
Just because you help them file the application doesn't mean you can speak for them on appeal. Now, show me where that's in the application, and I'll buy you lunch.
It's not there.
I'll buy you a good lunch. Or I'll be so glad that you pointed something out that I missed, I'll buy you lunch. It's not there. It is not there. I know that from legal fundamental principles. You know what I mean? So, I get so frustrated with the hide the ball, dodge it, duck and weave, ignore.
All of this was created by you lawyers.
Well, not this particular one.
Not
but
you in
I
particular.
I get your.
But you understand.
Yeah, I mean, well, it's a system of laws.
It's a system
That
of laws.
comes from the government, which is
Yeah.
most folks are lawyers. I agree. There's a lot of that involved in it.
Yes, it is. It is.
this
And
is-
I meant no harm. I have lots
No.
of good friends who are lawyers.
That's right. But I think when I go on that, you were going to ask something. Do you remember what it was?
Well, I was just thinking about how intimidating that might be, for someone to wade into that and not know the rules and then just get automatically cut off like this lady was because rule number 1, she didn't have the authority to be there.
Yeah. And the court in that
And
case,
how would she even know that?
Yeah, and the court in that case was sympathetic to that.
Yeah.
And they, instead of because the state moved for dismissal, dismiss the appeal, and done, it's over with.
Yeah.
And they would have been entitled to that. But the judge knew she was at a disadvantage, and the judge said, I'm going to give 30 days
Yeah.
for her to accomplish power of attorney.
Yes.
Now, the problem with that was, she was giving her a little bit of a break.
Yeah. Yeah.
And that's what the judge does. It's a court of equity. They don't just
Yeah.
bulldoze over people. And so that
Yeah.
was the right thing for the judge to do. But the problem was the applicant, the father, was incapacitated.
Yeah.
So he could not sign a power of attorney.
Right.
Kids can't do it. The
Right.
only remedy we have now is a conservatorship.
Yes.
Okay. Now, is it possible to do a conservatorship in 30 days? Prior to this, I would have said no. That's when I got on board.
Yeah.
And the only thing I could do is a conservatorship. And we did it in 29 and a half days. And I did it with the help of the guardian ad litem who was appointed. I did it with the help of the judge. It was like a Murray County case. He agreed to hear it when he was sitting in like Lawrence County or Giles County.
Yeah.
Because it's the same judge. They can do that. But they got to agree to do it. And a lot of times they don't because they say, well, I got plenty to do in Lawrence County. I don't want to do Murray County cases in Lawrence County. But I explained the situation. And the judge was very sympathetic, and so they did. And so we got the conservatorship in time. And then we had the next hearing. Then now she was able to be represented. But anyway, you can fix this stuff, but you got to know what it is you're fixing.
Yeah, that's the advantage to coming to someone like yourself who expertly knows the rules and knows the arena that the rules are played in.
I wish I expertly knew all the kind of stuff that could actually happen.
Well,
because I never saw some of that coming.
Well, you're equipped though to find the answers.
Yeah, I mean, again, like I said, when they step out of the rules, we can deal with general fundamental legal principles, and that's going to a higher court. Right. They can't just sandbag it. You got to have a remedy.
Yeah, that was probably the one of the most interesting parts of the story is that they were just going to let it go into the abyss.
Well, that got their attention. I didn't file it, but the fact that I did.
Yeah.
I mean, I notified them I was going to do it. Yeah. When I notified it to them, when I told them, they knew what I was talking about. Yeah. Because if you go to a typical lawyer and ask them what's a writ of mandamus or a writ of quo warranto, I mean, I'm not saying there's anything wrong with not knowing. Yeah. But they probably don't because it's a rare it's a rare cause of action.
Interesting.
Writ of habeas corpus, everybody hears about that. That gets used a lot. Right. But the other ones, not so much. But they're there, and they're called extraordinary remedy. I mean, it's extraordinary because I have a court that's not doing what it's supposed to do. Yeah. Who can order a court to do something? Only a higher court.
Yeah, you got to go to a higher court.
You got to go to their boss, kind of.
Well, which brings us to the Supreme Court.
Yeah.
Well, you probably don't want to go there.
I'd love to, but this is probably not the time or
probably
the place.
not the time.
But again, I listen to some of those arguments and stuff, and I love the way when you're a higher level judge. Yeah. I mean, those folks, their mind operates on a different plane. Yeah. And I don't mean that condescendingly. I mean on a higher plane. And they think things through. I mean, they just literally think them through, and they definitely apply fundamental principles, stuff like that. They stick the precedent. They don't make stuff up. Yeah. I mean, they look to see what have we done. It's called precedent or stare decisis. Once done, always. Once settled, always settled, kind of thing. Unless there's a reason to step out of that and change something, which happens from time to time because you live in a fluid society. But it doesn't happen as often as you think. Yeah. I won't get into it, but there was a lot of stink going on a while back when they revisited the Roe v. Wade thing. Yeah, they did not really change anything. I mean, that case was not about abortion. Or having one or not having one. That case was about the state's authority to control what's a compelling state interest. Yeah. And the end result was we're not saying you can get an abortion at this trimester, that trimester. We're not saying you can't. We're not saying anything about abortion. We're saying the states make up those rules, not the feds. Right. And they are right. They are absolutely right. Yeah. It's a state right under the 9th Amendment. So anyway, I don't use the word abortion, but I mean, so I don't want to go there. So if you're pro or con, don't call me. I'm not going to argue one way or the other. I'm just saying, from a legal standpoint, that's all they did.
That's the way they made their decision.
But the news says they overturned it and reversed it, which sounds like it says, oh yeah, nobody can ever get an abortion ever under any circumstances. It had nothing to do with that. But that's what they protests were all about. And, I mean, why don't you go if you want a copy of the Supreme Court? It's called a slip opinion. If you want it, they'll give you one for free. Yeah. Why don't you go get it and read it? Yeah. Then decide whether you want to go protest or not. Yeah. I mean, there's no substitute for education. I mean, common sense is a superpower.
Well, unfortunately, as you know, and we're probably getting off subject just a little bit, but our society, we're led by the news headlines, which doesn't always tell the real story.
Yeah, that's unfortunate. There's an old saying.
It's really unfortunate.
There's an old saying says, if it's in print, it's got to be true. Yeah. I mean, so if a lie is in print, it's perceived to be the authority. Yeah. And with the internet, I mean, everything's in print in some way or another. But you have to be intelligent about taking in the news. First you got to know and understand it may not be the actual news. It may
That's
be
right.
slanted or whatever. But like I said, we won't go there. But
Yeah.
well, and the whole concept of listening to the news and trying to get to the truth of it and understanding of it is the exact same thing that I do with my seminars. We talked in the very beginning of the show that it
Right.
was educational,
Right.
Educating you on your options. I mean, you could educate yourself on your options. I think it would be hard to do because it's hard to find that stuff out there.
Yeah. Yeah, it is.
Some of it's embedded in the TennCare Act or the Federal Medicaid Act. I mean,
Right.
if you go ask somebody, they're not going to tell you, because they're going to say, well, I don't give legal advice, or I
Yeah.
can't give legal advice.
Right.
There's no place where it's just written, okay, hey, here's something you can do.
Yes.
It's written in our Deficit Reduction Act
Right.
what we can do. And so that's how we do it. But
Yeah.
so you might not be able to find it, but you can educate yourself. What I'm offering is a way to get something a little more than the Reader's Digest version of it up front, let you know you have options, basically how those options work.
Yeah.
Now you can take the thought process of applying it to your personal dynamics and situation and see if that's a solution for you. If it is, let's talk about it.
Yeah.
If it's not, I mean, we'll still be friends. I mean, it's now it's an informed decision on your part.
Right.
You don't ever walk into an attorney's office and just let them do what they think is the best for you. Now, I'm not saying there's ones that won't do what's best for you, but you need to be involved. You need to be involved in the decision-making process.
Yes.
It needs to be explained to you. And if they're not explaining it to you, get another attorney.
Yeah.
Because it's incumbent upon them to do that.
Yeah.
If you're going to hire them as an advocate or a litigator, they have to be forthcoming with you and let you know.
Yeah.
I don't mean just keep you posted of how it's going, status report.
Right.
Then you explain to you what they're doing, the theory behind it, why you're doing it. Now, it doesn't have to be a law school lecture,
Right.
but you can give the Reader's Digest version and get a pretty good understanding of it.
Yeah. Yeah.
So if they're not doing that, you're not being represented.
Yeah.
How do you know if they're working in your best interest if you don't know what they're doing?
Well, that's true.
Hey,
That's
don't
true.
worry, I'll take care of it. It's like, that's a non-answer. In my opinion, that's negligent. That's malpractice. You have to keep your client informed. We have all kind of canons and professional responsibility rules that talk about that. So, and I kind of do that in a group setting, at least to get started. You want to know, some people will say, well, I'd like to write a will, last will and testament. I don't have one.
Yeah.
And I say, okay, that's great. We do wills, but would you like to hear about some options? I'm overwhelmingly I get the response. I didn't know there were any. I thought a will was all you could do. It's like, well, no, there's other things you can do, and would you like to hear about them? Most people would say, yeah. And when you do hear about them, by far most people like the options better than the will.
Yeah.
So,
absolutely.
It's an education at least to the level to make an informed decision. How do you make an informed decision whether to do a will or not a will if that's the only thing you can do?
If you don't have the information to make
if that's
an
the only
informed
thing you can
decision.
do,
Yeah.
or you think, it's not a decision at all. You
Right.
just do it. But you have to be, you're entitled to know what's out there.
Yeah.
And so you're not entitled for this hide the ball business.
Well, this case that you shared with us today, and your frustration was evident, is still in play.
Yeah, we're still
in play.
we actually I think we've provided them with the timeline already.
But you have provided them with
With that timeline, which is all the.
Well, I'm talking about what the solution actually
Yes.
is,
Yep.
and it ought to be settled pretty easily.
Yep. Well, that's my hope.
That's your hope.
And there was a glimmer of hope coming from the other side in that discussion. I had to read between the lines, but that's what it sounded like
Yeah.
to me.
Yeah.
And if I'm all for if you're dealing with somebody in the law, everything's adversarial, right?
Yeah.
You have an opponent that's you want to do something, they want to do the opposite, and it's adversarial. I'm all for giving them an out.
Yeah.
In other words, could I make a big deal of the fact that in 90 days and they took 110?
Yeah.
Sure, I can make a big deal of it. But if they're gonna sit down and try to resolve it, I'll give them an out. I'm gonna say,
Yeah.
okay, yeah, if we can talk and go through this, and you will really listen to me and look at my stuff, actually give me a meaningful
Right.
talking to and a meaningful review.
Right.
If you'll do that, I'll be more than happy to reach an agreement with you, and we'll shake hands and part friends. I didn't like the way we got here, but we ended up where we wanted to be.
Yeah.
I'll give you an escape route. Even if you do something wrong, I'm not out to blow the whistle on you. But what I expect if you do something wrong, and I point it out, is that I would like to see some effort to prevent reoccurrence. That's what I'd like to
Yeah.
see. When I see the same mistake over and over and over and over, one of these days I'm just going to say and ask, don't you guys ever generate a memo and send it down to the caseworkers and say, look, you guys are calculating the snapshot date wrong. Here's how you do it.
Yeah.
Because we see that mistake time after time after time, and I don't think they correct it, and that's sad. They should, but I don't know. Like I said, If I was a fly on the wall,
Do
I
you
might,
have any idea how many people are actually in that department?
Oh gosh, I do not. I mean, I
mean, I
I,
have no
never
idea.
really thought of looking at, but there's local, and then there's the next level up, like a
Yeah.
district. There's state. So yeah, I haven't never looked. Interesting
Probably
question.
quite a lot.
Might be interesting. So anyway, let me just wrap up with the
Yeah, we're gonna
seminar
have to wrap
coming
it
up,
up, aren't we?
Yeah, got there. I didn't think that was the only thing I was going to talk about, but as you say, as you get talking about it, I get into it. I get fired
Well,
up.
you do want to remind everybody about the
Seminar. I am.
Yeah,
The
absolutely.
seminar is coming up on May the 18th. That's a Saturday. On Saturday, we do wills, trust, and the nursing home. Now, I won't get into all that at the seminar, but we get into the other things. And we do this at 10 o'clock in the morning. We're doing it right here at WLX radio station, at the back of the building.
Right.
Don't come in the front radio station. In the back of the building, there's a set of double doors back there. You can't miss them. You just come in. That's the place you want to be.
Very good.
And like I said, we start promptly at 10. If you want to come to that, call my office at Pierchoski Estate Law, Pierchoski Elder Law. The number is 931-363-7222. If you don't remember the number or want to ask a question or RSVP by email, you can go to my website, and it's easy to get to, estateplanstand.com.
EstatePlanStand.com.
And we do this show every Friday morning from 8 to 9.
That's
So-
right.
and it's
Every Friday, 8 to 9.
I'm sorry, what did I say, every morning? No, we don't do it that often.
Every Friday. Every Friday,
Friday
from 8 to 9.
morning from 8 to 9.
Tune in here to WDXE. Listen to Stan Pierchoski. Pierchoski Estate Law, located in Pulaski, Tennessee. That phone number again, 363-7222. Stan, always a pleasure to be with you, my friend.
It is always a pleasure, Jeff.
Have a wonderful weekend, and good Lord willing, we'll see you next Friday.
Thank you.
Sounds good? All right, see ya. We're going to have a moment of silence, but not many moments, so stand by.
This is WDXE, W287AA, and W2.